be administered. And the argument says, oh, well, that only kicks in if you've decided that the arbitrator is going to decide arbitrability. And then these rules determine how he administers it. We say, and the cases say, that's not a reasonable interpretation. If that were a reasonable interpretation, then when a court decides jurisdiction or venue or forum nonconvenience, it's not administering the lawsuit, because that's a preliminary question, and that may kick it to another tribunal like this would. Of course, that's the administration of the lawsuit, and that's the administration of the arbitration. It's everything that an arbitrator decides, and the word administered, as all the cases say, covers everything, including the arbitrator's resolution of the issue of arbitrability. So the last point that the district court made was that the rule, the arbitration rule, says that the arbitrator has the power to decide the issue of arbitrability. And the suggestion we get from our opponents is, well, it doesn't say that the court does not have a concurrent power. It just says the arbitrator has the power. Well, every case to decide the issue is also disagreed with that. Well, I think that one exception. And that is that it says the power. The arbitrator is given the power. And we suggested, and there's a case right on point that suggested, Blanton out of the Sixth Circuit, how do you administer a regime in which both the court and the arbitrator have the power? Well, how do you do it? The plaintiff runs to court and says, you have the power. And the other party runs to court and says to the arbitrator, you have the power. It's a race to the courthouse. That's what this Sixth Circuit court said in a case called Blanton. It said you can't administer something like this. Whoever runs to court first is going to win if there's concurrent jurisdiction. It's got to mean what it says, the power. And that's what the cases say. We've not heard a response to that particular argument.
Counsel, so one of the other things that Judge Thapar said in the Blanton case is that the parties contract in the shadow of the law. And so this contract was entered into in 2016. It seems to me that this principle of this language being deemed clear and unmistakable was pretty well established by then. I mean, at what point does it sort of cease to be something that we look at sort of in the abstract as if we're writing on a clean slate versus this is just something that, you know, are the parties expected to understand that all these courts have said for years at this point that this is deemed clear and unmistakable language? Is that is it right? Was Judge Thapar right that that's part of how we should be looking at this?
Respectfully, Judge, I think my opponent would say that the parties are not required to read the case law, and I don't think they are, and I would never suggest that. And I would agree with him on that. But they are required to read the language, and the body of case law, virtually unanimous body of case law, tells you, I respectfully submit, obviously this court's going to make its own decision. I would never suggest that it's going to rubber stamp other cases, nor have any other decisions on this issue. But what I'm suggesting is this overwhelming weight of authority, which has established this as the clear weight of the law in this area, informs the question of whether this language is clear and unambiguous. It is part of the lexicon. It is an accepted rubric under which to conclude that the language is clear and unambiguous. And independent of all those cases, it is. It is. You can't dump the AAA rules all into the website. Even with a piece of paper, Judge, you'd have it as an attachment. You can't dump all the AAA rules into the terms of service, page after page after page. Even there, if on paper, it would be an attachment. Let me go back to the rationales. We've gotten one more argument that our opponents made, and that is that the rule should somehow be different if the people who are executing the contract aren't quote-unquote sophisticated. We say first, you introduce no evidence that you're not sophisticated. You may be very sophisticated people who want to rent an Airbnb. They said, well, that's your burden. Wrong. It's our burden to show that there's a valid arbitration provision, which was never denied, and this is all in the standard of review, It's their burden to show that the issue was not arbitrable because of sophistication or for any other reason. There is no record on that point. That's the end of it. Second, on the merits, the cases are overwhelming that the sophistication of the parties is not a factor. If you're applying an objective test, which is this ambiguous or not, how are you going to factor in some subjective consideration of the sophistication of the parties? Where does that work in? How does it fit in? And the answer is it doesn't. The sophistication of parties is not relevant to the question of whether contractual language is clear and unambiguous. Everybody is supposed to be able to read it if it's clear and unambiguous. And respectfully, once again, the overwhelming majority of cases say that. This new 11th Circuit case involved unsophisticated parties who had bank accounts. And the 11th Circuit says we've said over and over that sophistication is not a factor. We've cited a plethora of decisions. Last point. We've said that even if the court decides that this is a question for the court and not for the arbitrator, this is clear and unambiguous. This court can decide it for itself, de novo. I don't want you to. I don't think that's the right way to go here. That's not what I prefer. But if you look at this, if you look at this language as against the allegations that are made by the Does in their complaint, it is certainly related to and arises out of the arbitration agreement, the agreement with Airbnb. You don't even have these claims unless you sign that agreement. You're relying on the terms of service, which are part of that agreement. We've given you a whole row of cases on that, and I respectfully submit the briefs on that. I don't think that's a close question, but I don't think that's where the court respectfully should come out. I think this language is clear and unambiguous as a matter of law, and I think this court, making its own decision, should join the overwhelming majority, if not unanimity, of other courts in finding this to the same effect. Thank you.
Counsel?
Good morning, Your Honors. May it please the court, Tom Sider with Brandon Humphreys and Berman for the respondents, Mr. and Mrs. Doe. Arbitration is supposed to be a matter of consent. The question here is whether the Does consented to have their claims sent to an arbitrator, and more specifically, whether they agreed to delegate the question of arbitrability to an arbitrator and away from a trial court. There is no clear and unmistakable evidence here to that effect, and that is the standard. What the United States Supreme Court held was, this question of arbitrability is rather arcane and difficult to understand, and so as a result, the law creates a presumption, and the presumption is that a trial court is going to make this decision in the place of an arbitrator.
Well, let's look at what's in the contract first.
Yes, sir.
That's determined as a matter of Florida law, is it not?
Yes, sir. Under Florida or federal law, the express language of the contract is what will control.
So what is within the contract itself, what composes the contract is a matter of Florida law?
Yes, sir.
All right, so when we reference the AAA rules, is that included as part of the contract under Florida law, as incorporated by reference?
It is incorporated, Your Honor, for the purposes specified in the agreement
Is it
itself.
part of the contract?
Yes, Your Honor, so long as the parties have an arbitrable claim that is being sent to arbitration. So, sorry.
Okay, but it's part of the contract, right?
So
Your position is not that under Florida law, the AAA rules are not part of the contract. Your argument, as I understand it, is even though it's part of the contract, it doesn't suffice under the Federal Arbitration Act law to be clear and unmistakable under first options.
That is broadly our argument, Your Honor. I was trying to make a little bit more of a specific point, which is that incorporation is not an all-or-nothing proposition. There are circumstances under which you can incorporate a collateral document, but only if a certain set of events arises. So what the contract here says is the parties agree that they will arbitrate any claims within the scope of the agreement. Basically, they agree to arbitrate arbitrable claims. And then what it also says is that that the AAA rules will apply to any arbitration.
Well, it seems like if you have something is either part of the contract or not, you may have conditions precedent to the operative terms of the contract
That maybe is a better way to put it, Your Honor. There are conditions precedent to the AAA rules coming into play here. And so when you synthesize those two provisions I was talking about, what you get is the parties agree that the AAA rules will apply to arbitrable claims. But there is no definitive answer or any answer at all provided in the agreement as to who's going to make that initial decision of arbitrability.
Well,
It seems like if you've got the actual terms of the contract include the AAA rules, right?
Yes, Your Honor.
And it's in there. It's incorporated by reference, therefore it's part of the contract. And then you look at the language, and the language seems to be pretty clear and unmistakable that the arbitrator is going to decide the arbitrability of any claim or counterclaim. So why is that not clear and unmistakable under the federal law?
Yes, Your Honor. So I would have two answers to that. And the first is that the does would need to know that they need to look at those rules at all, and that the rules are not going to apply only in the event that the claims are sent to arbitration.
So they have to look at them for it to be operable as a matter of law?
They need to understand why the rules are being incorporated, Your Honor, and for what purpose. And so if they are told you only need to look at the rules to find out the procedural rules that are going to apply to a future arbitration
So
proceeding.
if I'm looking online at a real estate contract and it incorporates other documents as a matter of law, if the person executing the real estate contract, if they don't look at them, it's still not binding contract?
I think, Your Honor, if the collateral document does not end up becoming, if the condition precedent to the collateral document never ends up being satisfied, then they don't need to read it. Or, I guess, put a different way, they only have to read that document for the purpose specified. So here, the does need to read that document if they want to know how their arbitration is going to proceed, if they want to know what the filing fee is going to be, where it's going to be held, things like that. But what they don't need to know or intuit is that the threshold question of arbitrability is going to be answered by those procedural rules.
Where in the contract does it say any of this? Where in the contract does it say you only need to click this link if you're concerned about how your claim will be arbitrated? I mean, I guess this is a great argument if we imagine into the record and into the contract these limiting principles. The trouble with the argument is that, as I read it, none of this is in the contract, and when you click on the link, it says that the question of arbitrability will be decided by the arbitrator. Am I wrong about that?
You're not wrong about that, Your Honor. If somebody gets to Rule 7A of the arbitral rules, they will see that an arbitrator has the ability to decide questions of jurisdiction, and that includes arbitrability. I do want to focus on the language used there, because it does not say that an arbitrator will decide arbitrability. What it says is that an arbitrator shall have the power to decide arbitrability. In international arbitration circles, that's known as competence language. And what they say is it has a positive dimension, but not a negative one, meaning that it gives the power to an arbitrator to make this decision, but it's not supposed to displace the trial court's inherent authority to make that decision too. And I think that's doubly so here, where there is this presumption that a trial court is going to be the one to make the decision on arbitrability.
Are you saying then that a trial court interpreting that provision could correctly decide, notwithstanding the language, that the trial court, has the power to determine arbitrability?
Yes, sir.
Like let's say you're right, and this doesn't immediately foreclose the question. The question comes before a trial court of general jurisdiction, and the only language in the record is that the power shall be vested, or the arbitrator shall have the power. There's nothing else in the record. You're saying that, consistent with principles of general contract interpretation, a trial court could, without committing error, nonetheless say that it has power to determine arbitrability.
Yes, Your Honor.
Okay.
I think that...
Hum a few bars of that for me. Tell me how you get there.
Yes, sir. So shall have the power is actually a phrase that has been interpreted in a number of different contexts. The Constitution says that Congress shall have the power to levy taxes, but courts have held that doesn't mean that other governmental entities don't also have the power. And maybe a better analog is there are federal statutes that say that federal courts shall have jurisdiction over certain matters. And what the United States Supreme Court held was that does not displace the state court's presumptive jurisdiction over those same matters. So shall have the power is a phrase that has meaning in the case law, and the meaning is precisely what we've argued here. It is permissive but non-mandatory. And if Airbnb had wanted to make this mandatory, what they would have written is, the arbitrator will decide questions of arbitrability. Shall have the power, it has a specific meaning, and what we know from some of the scholarship surrounding this is that the reason that this language was created in arbitration agreements is precisely so an arbitrator could have the non-exclusive ability to decide questions of arbitrability. And that is...
Can I simplify this maybe a little bit for me? I mean, it seems like it's clear that under first options, what we're trying to determine is what did the parties agree to, which is what you do in every contract case. Is that correct?
Yes, Your Honor, with the added caveat that it is not just a matter of whether the parties agree to something, but whether this specific
Whether there's clear
concept-
and unmistakable evidence as
Yes,
to
sir.
what they agreed to with respect to this specific issue.
Exactly
But it's
so.
still a basic contract interpretation. So you apply the basic rules, right? And that means that you would look at the whole agreement.
Yes, sir.
Okay. And it seems like the argument is in two sections. One is, does the language in the rules count?
Yes, sir.
And the first part of the argument seemed to focus on an argument that they just don't count at all for whatever reason. But you gotta, I mean, you look at the whole agreement, so you would agree that the rules count in determining what they agreed to.
Yeah, so Your Honor, what I was trying to argue before is that they are incorporated for this specific purpose. And I guess a broader point to make is even if the rules are...
Do they count or do they not count?
Yes, Your Honor, they do
Okay,
count. They
okay.
count, and I think that...
So then the second part of the question is, does the language in the rules, is that clear and unmistakable evidence? And it seems like, to me, that, again, you go back to the principle that you look at the whole agreement. So you can't read that in isolation if there's, and you would go back to the first part of the page, the first part of the contract, the more conspicuous part, and it says, all disputes, the whole controversy is going to be arbitrated. So why wouldn't you, if there was any question, and I'm not conceding necessarily that there is, in looking at the rules themselves as to what's going to be arbitrated, why wouldn't you just look back at the other and say, well, any reasonable person reading this it's clear and unmistakable that they agreed to arbitrate according to these rules, and these rules say this, and it just seems pretty straightforward.
Your Honor, so we do disagree that the rule itself, even if located, is clear and unmistakable in that it is permissive and non-mandatory. But I think there's also a problem of, the clear and unmistakable standard is not supposed to require these sort of inferential leaps. I mean, you're talking about cross-reference rules and tracking down this rule on jurisdiction, all to try to figure out a concept the United States Supreme Court has recognized as arcane and difficult to understand. And sort of the whole thrust of first options is people are going to overlook this concept. People don't know what arbitrability is in the first place. I didn't know what it was before I had this case.
Let me ask you this, because as you stated when you began, that arbitration is a question of consent.
Yes, sir.
And the party has to waive it, their right to a jury trial and consent to arbitration. So obviously it's an important decision that a party makes. And what I'm hearing here today is that the agreement, they can attach as many attachments as they want to online. You can have 100,000 pages. And in there, in a footnote someplace, they can say, oh, by the way, yeah, the arbitrator gets to decide whether this goes through arbitration or not. And that's okay, as long as it's in part of the package, as long as it's part of the text of the package. It's okay. And that's pretty much the law. If we go in that route, that's going to be the law of the land on everything. Online, just attach whatever you want to it, say these are appendixes, these are whatever, and it all counts. Is it not what we're doing?
Yes, Your Honor, that's what Airbnb is asking this court to decide today, is that it all counts. So long as you put it somewhere in the agreement, no matter how buried it is, no matter how far away it might be from the actual arbitration provision itself.
Well, don't we have isn't part of our obligation in these cases, since arbitration is a question of consent, and before somebody waives it, that we make a decision as to whether or not the language was clear and unambiguous, so the person knew what he or she was waiving?
Yes, sir, I do think that's absolutely correct. That is a decision for this court and looking at this contract here, just because, even if this court were to find the rule is clear and unambiguous, the placement of it is significant on its own. This is...
So first, you would agree that first options doesn't have a conspicuousness requirement. There's no requirement that this particular part of the agreement be placed in bold or highlighted or put on a front page or anything like that. It's simply whether, if you look at the whole agreement, it's clear and unmistakable that that's what they agreed to. That's what the contract says.
Your Honor, I would agree that first options doesn't say one way or the other, that the language needs to be conspicuous. And there, in fact, they weren't even interpreting contractual language. There was a question of intent as appearing at an arbitration proceeding. So there's nothing in first options that says how exactly the language needs to be portrayed in an agreement. We would argue that clear and unmistakable means express and explicit, and that there is nothing express or explicit about leaving this language out of the arbitration provision itself and burying it in this rule.
I don't see very much evidence in light of what Mr. Perwin said at the very outset of the argument that anything is really buried in this contract, right? You don't quarrel with the clear statements in the contract about how it affects people's rights, right? That's there. That's in the contract. And
Yes,
how Airbnb encourages the party, pretty like at the outset to read everything and advises the parties that there are things in the agreement that they need to pay attention to, right? That's over and above what first options would require.
Your Honor, yes, I would agree that it does direct the parties to read all this carefully, and it does, in fact, incorporate an entire set of arbitral rules. But they can be read, and what Mr. Perwin is asking you to assume here is that somebody in the Doe's position can and will realistically be able to read 22 pages of terms and conditions, and then 46 pages of AAA rules, and pull out this concept
Isn't
of
his argument
arbitrability.
instead just that it's there? Isn't his argument just that it's in the contract? It isn't about what anyone's going to read or not read. His argument is about what's in the agreement, right?
Yes, Your Honor, and we can assume that they're going to read. It's that over the course of reading these 60-odd pages, is it going to be clear and unmistakable to the parties reading that they are delegating this question of arbitrability, or even that they are going to understand?
Well, it's in the rules. It's there. It's not buried. It's not in a footnote. It's there.
Yes, Your Honor, it's Rule 7A of the AAA rules. It is there. It's a fair distance away from the arbitration provision itself, and there is, of course, we would argue a reasonable possibility that somebody reading those rules would say, oh, well, this is just what happens once we get to arbitration. This isn't something that is going to affect the front-end question of whether we go to arbitration in the first place. This is just an issue that is going to come into play once we're already there.
And it's not even in a bizarre place. I mean, in the rules, it talks about what the arbitrator can in fact rule on. Its own jurisdiction, and including whether something's arbitrable or not. Those things seem to follow with each other, do they not?
They do follow with one another, Your Honor, and I think the question is, well, twofold. One, whether somebody reading that understands that this is something that's going to apply in the front end and not once they're already in front of an arbitrator in California or wherever it may be. And the second thing is whether they would read shall have the power as conferring a mandatory, exclusive power on the arbitrator to make that decision, which there's cases, and we've cited them in the briefs, that say shall have the power means something else. And so at the very least, what we have here is a reasonable interpretation of the language. Not just reasonable, but one that is supported by the case law. Shall have the power means a non-exclusive right to make a decision. Just like federal courts shall have the power to rule in their jurisdiction, it does not mean that trial courts, state courts, don't also have the power. And so once you get to a reasonable interpretation, for us, that makes the language ambiguous. And what first option says is ambiguous language, which is to say language subject to more than one reasonable interpretation, cannot, as a matter of law, confer the power on an arbitrator to decide arbitrability. That's sort of the point of first options, is that we have this presumption and that we're only going to read this express delegation from a contract if there is no possible way that somebody reading could reach that conclusion and not something else. And so that is, I think at the end of the day, what this boils down to. Is it clear and unmistakable? And also, I think a lot of what we've talked about today, mandatory versus permissive and incorporation by reference and administration as a jurisdictional concept, These are all things that are not going to be clear and unmistakable to most people entering into these contracts. Clear and unmistakable means explicit and express. And as some of the justices mentioned in the questioning earlier, it is not a very hard problem to fix. It requires a single sentence, and we're not saying the AAA rules need to be reprinted. There is an arbitration provision already in the terms of service here, and all we need is a sentence that says an arbitrator and not a trial court will decide questions of arbitrability. And once that sentence is there, Airbnb's problems are solved, at least as far as this case goes. It's not a difficult fix, and it's something that would explain the concept of arbitrability to somebody reading the actual arbitration provision. It's something that would satisfy the clear and unmistakable standard.
So, counsel, why is the case law so overwhelmingly against you?
Yes, Your Honor. So that, I think that there were early decisions that kind of underanalyzed and underdetermined this question of arbitrability, and they reached sort of I think we describe it as inertia in the briefs. There's kind of a terminal escape velocity, and then they couldn't pull it back. There isn't really any analysis in most of the cases. Up until really the Sixth Circuit's most recent decision, no one discusses at all how this language could be clear and unmistakable. And so, the analytical foundation of these cases really isn't there. And on the other side, we have the Second District's decision, which has been followed by the Fourth District, and we have the ALI restatement of international arbitration. They're not in the practice of disagreeing with every Federal Circuit Court of Appeal, but they did so here because they said this language simply is not clear and unmistakable. The rule itself does not give exclusive power to an arbitrator to make this decision. So it's true that we have all these federal circuits, and I think that Airbnb's main argument, I think as we heard today, is that this court should follow the federal circuits. But respectfully, it's the contract and the clear and unmistakable standard that should control here.
Isn't the whole context of this, though, that you're reading, if I'm the consumer, I'm reading this, and it's very obvious that the whole point of this is to take this out of the courts and put it into arbitration. And if I read the whole agreement, as Justice Lawson was saying, I'm going to see there that also questions of whether something will be arbitrated are going to be part of that. So this whole notion that just in the abstract, by saying that someone has the power, that doesn't necessarily mean that someone else doesn't also have the power. I understand that in some contexts that might be true, but if the context here is kind of an either-or context, and if I'm saying that, one of the two options has the power, isn't it kind of implicitly saying that I am intending to put that, make that the exclusive job of the one that I'm giving it to and not the other?
I don't think so, Your Honor, and I think that actually runs into the problem that first option discusses, which is parties may understand, okay, I'm agreeing to arbitrate all sorts of claims related to this agreement. But what they're not going to understand is that there is this threshold question of who decides arbitrability, and that's the arcane issue that parties are likely and frequently do overlook. And so that's why that needs to be spelled out differently than the rest of the arbitration terms, and that's what first options is trying to say. I don't know if I'm into my time here.
You're well over it.
Yes, sir.
But we helped you with that. You can, if you would, sum up in about 30 seconds.
Yes, Your Honor. So I think, again, I want to make the sort of big picture point here that what we need in this contract is clear and unmistakable language. And what we have instead is an arbitration provision that is silent on questions of arbitrability, a cross-reference set of arbitral rules that give only under certain circumstances a permissive and non-mandatory authority to an arbitrator to decide questions of arbitrability. That is not clear. That is not unmistakable. And so we would ask this court to approve the decision of the Second District. Thank you.
Rebuttal.
May it please the court, if I have the time, I want to get through 5 points. Number one, every case is decided on its own facts, and therefore, respectfully, Justice Labarga, we had a contract that had 6 different references, and each one was to 500 pages, and we had 25,000 pages. We may have a very different case. The court may decide it a very different way. That doesn't mean it can't decide the case this way based on these facts. Number two, Justice Polson, the issue is decided by federal law, not Florida law. Those cases are collected at page 17, because it's under the Federal Arbitration Act,
Well,
federal statute.
under first options, it talks about and makes clear that even what is in the contract, we look to state law principles to determine what's in the contract.
Respectfully, Judge, that is not correct. It says it has to be clear and unambiguous.
Well-
I don't see a reference to state law. This contract calls for the application of California law.
When
But the-
deciding whether the parties agree to arbitrate a certain matter, including arbitrability, courts generally should apply ordinary state law principles that govern the formation of contracts.
Absolutely.
And then they
State
go
law-
on to address whether or not this extra condition, whether clear and unmistakable evidence or not, whether the arbitrability should be decided by the court or the arbitrator is a separate component under the Federal Arbitration Act. Can we at least agree to that?
Yes, we can, and I agree state law principles are very relevant, but this is all under the adoption of federal law. I'm not going to fight about it because I think the standard is
So
essentially
you don't,
the same.
let me make sure I understand. Are you telling me that you think it's a matter of federal law, not Florida law, as to what constitutes the contract?
As to what is clear and unambiguous, which is why I've pointed to the Florida cases, because when the case is filed in Florida court, then it's deciding an issue of federal law, but it's not bound by anything but the U.S. Supreme Court. It can look at the federal cases as persuasive. Respectfully, it's just deciding an issue of federal law.
Well, that's why all those circuit court of appeal decisions that all go your way are important, right?
Well, they don't have to go my way just deciding federal law. They could have gone the other way, but
But
it
look, I
happens
mean,
they
this is
go
a-
my way because I'm right.
This is a helpful, the point is, when we're trying to decide what the contract is, he's saying that's a matter of state law. The test for what's clear and unmistakable, you're saying is a matter of federal law.
Yeah,
So you want the answer to be that the state law says that the whole thing is the contract.
Exactly. And I don't mean to fight about it because I don't think it's important.
Yeah, I don't think you want to fight with me about it.
I don't want to fight with you. I don't want to fight with you about anything, Judge. We go back a long way. Point three. The question, respectfully, is not would these people or a given person understand this? A subject or not?
That's what we're talking about.
We don't know. We don't know whether these are the most sophisticated people on the face of the earth. They may have rented these things 100 times. They may be commercial lawyers. We don't know. There's no evidence, and it was their burden of proof. These guys may be geniuses. We don't know. And in another case, if they made a record on that, I could deal with it. Now, I have on the merits given you a plethora of cases that say sophistication is not an issue because it's an objective test. Is it clear? Is it unequivocal? What do you do with the issue of sophistication in answering that question? You can't. It doesn't fit. You look at it and you decide, is it clear and unmistakable if the other side makes a record? And they did not do so. Point three. This whole need, I just did that. Point four, power. Arbitrators have the power. They have the power. I said, what happens? And the court in the Sixth Circuit case, the Blanton case, says, what happens if that's true? They run to the courthouse. Whoever gets there first is going to win. There's no way to administer that. The arbitrator has the power. And we cited the cases on identical language that if the arbitrator has the power, that is the power. In the federal cases, there is a supremacy clause. And if there's concurrent jurisdiction, the supremacy clause says the federal, if they're in conflict, if there's conflict jurisdiction, the supremacy clause, the federal rule governs. It tells you what happens if there's a conflict. It tells you how to resolve it. We got a conflict. Somebody runs to the arbitrator, somebody runs to the court. We don't know what to do. And respectfully, you don't interpret statutes or contracts to be absurd or respectfully unreasonable. And that is why all these courts have unanimously said that when you give arbitrators the power and say nothing about courts, provision never mentions courts, it means they have the power. Final, I'm through. The cases are clear. The judges didn't just reflexively follow some line of decisions and say, well, they said it and we're going to say it. Courts don't do that. Courts may sometimes per curiam affirm, they may sometimes write short opinions, but they make their own decisions, as this court is going to do as well. And there are decisions
Mr.
that have...
Perlin, I've let you go on an extra minute and a half. If you go ahead and sum up in about 30 seconds.
Okay, there are decisions we cited that go through this in great detail, and they decide this question in great detail. There is a reason that all of these courts are on one side of the issue, not that they missed something, but that they were right. We respectfully submit the court should reverse and enforce this provision.
We thank you both for your arguments in this case today. The court will now take up the second case on today's docket, Lee versus the County of Volusia.
Morning, Your Honors, and if it may please the Court, Mohammed Jazeel here on behalf of Secretary Lee. I've reserved 5 minutes for rebuttal. At issue before this Court is whether the text and structure of the Florida Constitution requires that litigants satisfy a three-part jurisdictional minimum of standing to sue. And the answer, we believe, is yes. From the territorial Constitution on to our modern Constitution, the Constitution has always included the phrase judicial power. The court is now faced with a choice. Do you interpret that phrase judicial power broadly or narrowly? That was a choice that sister courts have faced in Oregon, Michigan, Texas, Idaho, Vermont, etc. And the issue comes down to how is it that you interpret the phrase judicial power. And our position is that the phrase judicial power should be interpreted narrowly, consistent with the United States Supreme Court's decision in Lujan, the text of Justice.
Go ahead. Well, I mean, this is obviously a super interesting question, but why are we even asking it in this case where you don't take any position on the actual judgment, what the court, finally said in its order doesn't require you to do anything. Your position all along has been you don't care who gets elected to these positions. You're going to, sign off on whoever gets sent to you. I mean, so why... we've got the overlay of the fact that the Declaratory Judgment Act was designed to kind of get around the idea that you had to actually have an injury in the typical sort of private law kind of sense, which I understand there's also an overlay of the judicial power. But why would we use this, of all cases, to get into this kind of huge sort of, cross-substantive thing that you want us to get into?
2 points, Your Honor. Number one, I'd point the court to Judge Makar's dissent, where he points out that in this case, where there has been no election laws are implicated, none of the Secretary's authorities and responsibilities are implicated. She was, quote, dragooned into court. And that can happen again and again, whether because of some
counsel,
action or inaction.
When you say that, it just sounds like to me you're asking for an advisory opinion in this case. And in your briefs, you talk about how courts shouldn't give advisory opinions. But obviously, we've got the constitutional provisions in certain circumstances that allow that. But ordinarily, the judicial power is not the power to give advisory opinions. And I struggle to understand how you're not kind of ensnared on that point yourself, because you are asking us to effectively give an advisory opinion about what should happen in future cases. Nothing that's going to affect anything in the outcome of this case, but what the Secretary will be subjected to in the future. So what am I missing there?
Your Honor, I'd like to address that point in two ways. One, a thought experiment. What happened if the interveners did not participate in this case? What would have happened had they not interjected themselves? Would there have been a default against the Secretary because she took no position on the issues? And that conceptually sort of frames, in my mind, the concern here. We have a case where the defendant was not taking any position on the merits of the matter, but the First District Court of Appeal went ahead and decided the merits. And now we have an opinion which is subjecting the secretary to actual lawsuits. There's one in the pipeline now over ballot images, which is making its way up to the court.
But it seems like if there are problems going on in other lawsuits, that the answer is to address that in those lawsuits. Not this is over. This has no impact in the specific judgment has no concrete impact on the secretary except for the precedential value that it might have in future cases. Isn't that correct?
Yes, Your Honor, and I guess conceptually you could see this as if this case is going to have precedential effect in future matters and this case has become non-justiciable on its way up, should the opinion itself not be vacated for that very reason? I mean, there's a federal analogy to this, the Munsingware Doctrine, right? Whereas the case is making its way up the court system, but it becomes inappropriate for the court to address the merits, the underlying opinion is vacated. So that could be one possible resolution where we don't have to deal with the consequences of the first DCA's opinion, as Judge Maycar lays out in his dissent. That's one possible resolution to that matter. In Munsingware itself...
Well, but you're not complaining about being subject to the first DCA's opinion with respect to the issue that you're raising here because you didn't raise it below and they didn't address it, right?
The issue being
the standing issue. The only issue that you're arguing here, you start off your brief by saying that the circuit court and district court simply chose to bypass the standing inquiry altogether.
Yes, Your Honor.
So you're complaining about an issue and an opinion that wasn't addressed in that opinion, and I would say that they didn't necessarily choose to bypass it. It looks like you didn't raise it.
So Your Honor, I take that as an argument concerning waiver, as my friend has raised in his papers. And here are a couple of points. If the argument that we're now presenting to the court is that standing is a jurisdictional threshold, it can't be waived. Number two, if you look at the actual record in the case and we look at the motion to dismiss that was filed, the appellate briefs that were filed in this case, we talk about how there's no case in controversy as to the secretary. There's no antagonistic relationship. Yes, we didn't use the word standing, but the way that we presented the argument, both at the circuit court level and at the first DCA, makes clear that what we're saying is there's no antagonistic relationship, there's no case in controversy as to the secretary. Third, Your Honor, I'd like to provide the context for the secretary's arguments. There was one snippet in the complaint that talked about the secretary's powers to countersign commissions once people have been elected. That is what prompted the secretary to make the argument she did at the motion to dismiss stage and in her appellate briefs at the first DCA. The first DCA, sua sponte, however, discussed the secretary's broader election authorities. So under the circumstances, if the point is waiver, Justice Lawson, we would respectfully suggest that A, standing can't be waived, and B, the facts of this case suggest that standing wasn't waived.
Can I ask you about doctrine, though? So it seems like in these cases where you have parties suing government officials trying to get, declarations as to what the law means or whether something's constitutional, it seems like they have this body of law, trying to figure out who's the proper government defendant in cases like that. And it focuses more on the defendant than on kind of the quote unquote injury or whatever the harm to the plaintiff might be. And the other side kind of makes a point that there's, value in sort of keeping those things, even though they're related, kind of keeping them analytically distinct. Do you have a problem with that body of law in the first DCA such that you think that we need to kind of replace it with this injury in fact thing? Or do you think that they just kind of misapplied it in this case? Because it seems like it's a close case as to whether they got that part of it right, but that doesn't necessarily argue, that could be an argument for just kind of saying that the doctrine itself is fine, but they misapplied it, versus you're asking us to make these very broad pronouncements about standing law in Florida in general that have all kinds of applications, that are way beyond what we would need to do to kind of address what happened in this case.
Sure, Your Honor. And I'll take that question and divide it into two parts. One, there's a special injury rule, which is a subset of standing law in Florida. Special injury to sue government entities, and there are exceptions to special injury. That was not discussed in the first DCA, but that is one of the two analytical frameworks Florida courts use for standing. Then the first DCA discuss the Francati case, which is a proper party analysis. So conceptually, we're talking about two concepts here. One is standing, the other is the proper party analysis. And to me, those two concepts are related but distinct. In federal law, it would be analogous to 11th Amendment issues and standing issues. There's overlap. We discuss who is or isn't the proper defendant in a case, but they are distinct. So I'm not asking you to undo the Francati case, but I am asking
But
you
isn't that what this is about? I mean, why? It just seems like why aren't why isn't the first paragraph of your brief saying, this case gives the Supreme Court a great chance to clarify the Francati thing and the proper defendant? Because that's really what this is about.
I disagree, Your Honor. I think the proper defendant analysis is, let me back up. I think standing is a condition precedent to the proper defendant analysis. You have to have the jurisdictional minimum, as we point out, of standing for you
But
to
in
then
this
go
case,
to.
standing, so part of the standing is obviously focused on the plaintiff and whether they've been harmed or whether they have a legitimate problem. Do you have a problem with the county having been the one to kind of raise these issues? Your problem is that they've raised it against the defendant that doesn't really have a stake in the case, which is obviously kind of puts you into Francati land, right?
Well, Your Honor, it puts us into the redressability prong of the standing test that we're arguing about. The redressability prong.
There's three, aren't there three? It's injury,
causation,
whether it's the
redress-
defendant, and whether it's redressable. So in this case, isn't this the second part that you're worried about?
It'd be the third part. So if there's a declaratory judgment entered against the secretary, what's the declaration saying? The secretary is going to not let the supervisor of elections put someone on the ballot? The secretary doesn't do that in county elections. So redressability is the main focus of our three-part injury test. In Francati and the proper party analysis, as laid out by the first DCA, the focus is, well, who has the statutory duties that are being implicated? Right, so that first prong of Francati's proper party analysis overlaps somewhat with redressability, but I think they are distinct. And I hope I answered the question.
Well, you haven't really answered the question of why. I just don't understand. I understand sort of the academic interest in this, having us write some magisterial thing on standing where we have to compare Florida judicial power to federal, and there's all these contested issues in federal law right now about injury in fact and who can do this. We have this very broad declaratory judgment act law that is clearly kind of trying to sort of, at the time that these things came into effect, there were all these questions as to whether declaratory judgments in general were consistent with the powers that had been under. I just don't understand why you're asking us to do this.
Your Honor, at its core, we're asking you to do this because the opinion subjects us to more and more lawsuits on a daily basis. And that's why we're asking you to do this.
But we could fix that by saying, if it's wrong, and I'm not saying that it is, but just by saying that, these types of duties that were invoked by the first DCA. So the first DCA explicitly rejected this whole idea that just signing the commissions is enough, right?
Yes, Your Honor.
They went into this thing about all, your duties and how it relates. And I can understand how, as a repeat defendant, you might think that that's overbroad. I don't know why you're not asking us, putting aside the whole advisory opinion question. But if we were going to give an advisory opinion on something, it seems like the appropriate thing would be on clarifying for the Secretary of State and your role in the elections laws. Like, is this kind of high-level sort of uniformity thing, is that enough to make you a defendant in every one of these cases? We don't need to reinvent the wheel on standing to answer that question.
So, Your Honor, if I understand your point, you're saying that you can get to where the Secretary is asking you to be by providing greater clarification on the proper party analysis under Francati and cases like it?
Yeah, what's wrong with that?
There's nothing wrong with that. There's absolutely nothing wrong with delineating what is or isn't the proper party analysis. I'm simply saying that there is also another way to get there, and that other way is perhaps cleaner, because the Francati line of cases are still developing on some level. The first DCA is Francati line of cases, writ of prohibition cases, they're in flux. There isn't a clear, or there is a standard, And if you look at the Francati, they have a three-part test. The second two parts are implicated if you don't cross the threshold under the first. The third part of the Francati test overlaps with the first part of the Francati test. So it itself is in flux. But we also have standing law that's in flux in this state. We cited in our briefs 2 circuit court decisions 4 days apart that relied on completely different tests. So there are 2 ways to get to where we're asking the court to get to. That's true.
If the Secretary of State should not be here, who should be?
If the Secretary of State should not be here.
Yeah, who should they have sued instead of the Secretary? The governor was dismissed, right?
Yes, Your Honor.
And you said the Secretary of State also should not be involved in the lawsuit. Who should be on the other side of this?
The supervisor of elections. If someone is an applicant and they're saying that under Volusia County's charter amendments, no election should be had, someone who is applying for one of these appointed positions could sue the supervisor of elections who said that they're holding an election. Or the inverse is true. If someone wants there to be an election and the supervisor is not holding an election, they can sue the supervisor of elections saying, you ought to hold an election. We think that that's constitutionally required. That would be the appropriate case. But here we had folks sue the Secretary of State. And again, just conceptually, if there weren't interveners in the case, there would have been a default because we've taken no position. And so you would have had a constitutional amendment that was passed by the voters and the Secretary of State has no position on the merits, being the nominal defendant. How would that have squared with the exercise of judicial power?
Well, what would the supervisor of elections likely have taken the same position? We take no position?
I don't think they could.
It is what it is. Whatever the law is, that's what it is.
Well, Your Honor, I think respectfully, the supervisor would have been in a different position because the supervisor has a duty under the Florida Election Code to qualify candidates, right? So if there's going to be an election or not going to be an election for a countywide seat, it'd be the supervisor of elections who has an actual task to do. And there could then be some kind of judgment that says, supervisor, thou shalt hold an election and qualify people.
But why would you assume that the court would, in the absence of any kind of adverse presentation, why would you assume that they would go ahead and address the merits anyway?
So, Your Honor, again, if there were no adverse presentation, then the Secretary were the only party to the matter, and the court, as the circuit court in this case concluded.
No, but you don't know. The court has discretion. They could say, look, I'm going to whip out May versus Hawley. I don't need to get into, the federal 3-part standing thing. It says that, one of the minimum things to make it judicial is that there's that there's adverseness, that there's a true controversy here, and maybe the court wouldn't have decided the merits.
But that happened here, Your Honor.
Because there was adverseness.
There was adversity here, but May versus Hawley was trotted out. The arguments were made that there's no antagonistic relationship, no controversy, but the merits were addressed because the interveners were there. Interveners under Florida law are subordinate to the original parties.
Well,
right?
these guys weren't. But anyway, I'm sorry. I don't mean, I'm not.
Okay, counsel, you're well into your rebuttal time, but I'll give you another 30. I'm going to add another minute because we helped you use it. So you can keep going, but Your
Honor, I will address my friend's arguments. Thank you.
May it please the court. Barry Richard, representing the Florida Association of Court Clerks. I've had the honor of appearing before this court numerous times in my career, but this time what brings me here is truly unique. I have no opponent in this case because the Secretary and my clients have no disagreement as to anything that really matters here. The reason I'm here is a peculiar set of circumstances that occurred in this case. My client's sole interest is in sustaining the judgment below. DCA unanimously affirmed the judgment on the merits, and no one now before this court challenges the judgment on the merits. So I would not be here were it not for the potential ramifications of a dicta disagreement in the District Court of Appeal. The majority of the District Court held that the Secretary was a proper party. Judge Makar agreed that on the merits of the case, but believed that the Secretary was not a proper party. However, he concluded it made no difference because my clients, as interveners, were the real parties in interest and had vigorously argued the case. So the case was appropriately handled, and the lower court made an appropriate decision. Here's where the problem occurred. In response to Judge Makar's dissent, the majority opinion says that they disagree with him. They believe that the intervenors were not full parties because the trial court order didn't make them full parties. And then the comment is made that if they were not full parties and the secretary were not a proper party, there would have been no adversity for purposes of jurisdiction, and that's why I'm here. That's the only thing that concerns me. And my position on this is that, first of all, there is no rule that I can find in the law that says anything about the fact that a case must be dismissed or a judgment vacated because the intervenors, who happen to be the real parties in interest, are the only parties left in the case at the end. I know nothing. I looked, couldn't find anything that said that. The only thing that the case law says about this issue of being a full party is that an intervener that is not a full party cannot introduce any new issues into the case. That's the only thing the case law says. And as a matter of fact, in the case that I cited in the first district, the court pointed out that beyond that, interveners have all of the same rights as any other party to the case. My client never introduced any new issues. The only issues they ever discussed in this case were the ones that were raised in the complaint. Second, this whole issue of the fact that the trial court did not include the magic words "as full parties" when it granted an intervention that nobody objected to would be a classic case of form over substance, in which we would be saying that all the judicial labor that went into this case was fully and properly argued is going to be thrown out the window. And I don't understand what the public policy purpose would be for taking a position like that. So in short, my only purpose with this court is to urge the court not to reach the conclusion that was suggested, never really held by the District Court of Appeal, was suggested that if the Secretary of State was not a proper party, that the judgment below could not be sustained on jurisdiction. Now, what this also leads us to, that my esteemed colleague and I really have no fight before this court. The Secretary of State has never taken a position on the merits of the judgment below, and my client really doesn't care, in this case at least, whether or not the Secretary of State was a proper party. There is only one thing that counsel said that I do disagree with, which is how we got here, and which, again, I don't know that this court really needs to address, but it's an interesting academic question, which is whether we were really talking about standing. Because my position was that the argument that's being made to this court was never made below, it was waived. And counsel's response to that was, well, it's an issue of standing, which is jurisdictional. But as I argued in my brief, they're really not talking about standing. They're talking about the amenability of a defendant to be sued, which is a different issue than standing and is not jurisdictional and can be waived. Counsel gets to this by a winding path in an effort to get this court to adopt a theory that would enable him to indirectly allege that what they argued before was standing. But of course, we know they didn't. Counsel told you today they had no question about the standing of the plaintiff. In any case, Your Honor, I don't want to take up any additional time of the court. That's the only position of my client, and unless the court has any questions, I have nothing further. It's been a pleasure, by the way, to be here in person for the first time in 2 years.
Before you sit down, I know your client doesn't take a position on whether the Secretary of State's a proper party or not, right? But you've been around election law. What's your view? Are they a proper party or not?
I think that they are a proper party. And, Your Honor, what strikes me is the question that you asked, which is a question that's been around for as long as I've been doing this business. If not a proper party, who is? The difficulty that we have is there are cases in which there's a legitimate question as to the validity of a statute, but there is no enforcing authority. And so who do you sue? And we know the lawyers jump through hoops to figure out somebody to sue. And there have been proposals over the years to the legislature that they fix that. by telling us who would be a proper party under those circumstances. The Attorney General, the Secretary of State, whoever it may be. When counsel says they could sue the supervisor of elections, in this case, I agree with them, but in some cases, there is not anybody that would be a proper party. I don't know the answer to that, and I don't know that this court has the power to solve it. I wish the legislature would.
Thank you.
Thank you.
Rebuttal.
Your Honor, my friend Mr. Richard's clients filed a motion to intervene below. They did not talk about whether or not the secretary was a proper party or not. However, the tax collectors did talk about whether or not the secretary was a proper party. And the tax collector said on page 101 of the circuit court record that the secretary has no apparent interest in the outcome of this case, which is why the tax collectors asked to be included in the case. And conceptually, getting back to the relief that my friend was talking about, one way to look at why we're here is if standing is a jurisdictional prerequisite that every court must assess before it goes on to the merits, then was there standing at all, ever, in this case, if it was only the interveners who participated in the case and, based on my review of the record, didn't establish through record evidence that they had an injury in fact that was caused and that can be redressed. It's one way to look at whether or not the entire exercise was one advisory opinion. And if it was one just long advisory opinion from the circuit court all the way up to this court, then should any of the orders that were issued stand? And if that's the case, then
But if you're kind of a stranger, according to your own position, you're really a stranger to all this. This has got nothing to do with you. So why do you care?
because there are very real consequences that flow from what was said about us. And the fact that we have no ability to correct the record, to take up the issue of whether or not we should have been in the case to begin with, I think is important. And I think that gives us skin in the game. That is the only skin in the game we have. Because again, we took no position on the merits.
But asking it a different way, if we dismiss the case, what's the harm to the secretary?
If you dismiss the case, what's the harm to the secretary?
Yeah,
the harm is the precedential effect of the first DCA's opinion that continues to linger.
So you'd have to raise the issue in whatever case that there is to try to get that first DCA case overturned if you thought in those circumstances that were followed in some way would try to get it back here to this court. That's
So
what you're
we
saying.
would have to raise the issue in circuit courts that are confused about how to resolve the issue. Then we would have to go to the first DCA, which would be bound by the prior panel rule, by its opinion on proper party analysis. And then we would have to come to this court as elections come and go and mootness arguments are raised anew about an election that's happened.
Yeah,
to then see.
we do that a lot around here.
To see clear, Your Honor, my point is this. If we look at the federal universe again by analogy, you have concepts of mootness, you have concepts of waiver, and you have concepts of Article III standing that all reside in the same universe, right? And so we can have discussions about mootness and waiver. We can talk about elections issues, which seemingly are implicated here, but still get to the part of the issue that we're raising. And that's perfectly appropriate in the federal universe when they are looking at the threshold question of standing to sue and whether or not a court properly had jurisdiction from beginning to end. And that's why we're here. We're asking you to assess whether or not there was an appropriate exercise of judicial power from the beginning of the case to the end of the case. Because if our theory is correct and standing as a jurisdictional prerequisite, that needs to be assessed all the way through. With that, I have nothing further to add, and I would ask that you vacate the opinion as to the Secretary. Thank you.
All right. Well, we thank you both for your arguments in this case today. The court will now stand in recess for about 10 minutes before we take up the third case on today's docket.
All rise.
the court will now take up the case of the State of Florida versus Garcia. Counsel.
Mr. Chief Justice, and may it please the court, this case presents an important question of constitutional criminal procedure, but it's ultimately not the right case to resolve that question for the simple fact that Mr. Garcia has not established that he has irreparable harm. So I'd like to start this morning by explaining why the district court lacked jurisdiction, and I'll do so in two main parts. First, Mr. Garcia hasn't suffered any Fifth Amendment injury at all. That would happen only if he went to trial and were convicted on the strength of compelled testimony, which...
Well, let me ask you about a little different scenario in response to that point. What if this had gone a step further, and Mr. and correct me if I'm wrong, and this has already happened, but Mr. Garcia had been held in contempt and put in jail for the contempt for failing to follow the trial court's directive to produce the code. Would he have no remedy for that?
He could take an immediate appeal of that contempt conviction and sentence. And so that remedy is, of course, available to him. But
that would basically be an appeal of a final order.
Yes.
And but the underlying question of the validity of the trial court's order would be at issue there and would be resolvable there.
I believe so, Chief Justice Kennedy, and that's certainly a route that he could travel to get relief here.
And that if you win, that might be the next step, right?
That may well be the next step, or he may opt to reveal the passcode, and if we ultimately convict him based on the strength of whatever testimony and its fruits we obtain during our execution of the search warrant, he would of course have the option to direct appeal and raise all of the same Fifth Amendment merits claims that he raises now.
Sort of pregnant in that is a concession, I think, right? Are you admitting then that if it came to us in the context of contempt proceedings, the Fifth Amendment right would have attached, even though there is no, in fact, trial, that there's no jury, there's no attachment of jeopardy, a contempt finding would have triggered the applicability of a Fifth Amendment testimonial concern. Is that accurate?
Justice Curiel, we say, and this is the Gekas decision from the en banc 11th Circuit, that what he has invoked here is the prophylactic protection of the right, but not the core protection of the right, which is the protection against being convicted at trial based on compelled testimony. So he, of course, has the right to invoke if, in fact, there would be Fifth Amendment compelled testimony. But our basic point, at least on this first prong of irreparable injury, is that he hasn't suffered an injury one way or the other. That will happen only at trial. But we're not saying that if he were right about the merits, he wouldn't be able to invoke here. We think that he would be able to.
Is it Florida law in a context of civil cases that someone can invoke their Fifth Amendment and then have that review by cert because it will present irreparable harm?
So it's true that there are some district court decisions that are out there in the civil deposition or subpoena context. We haven't taken a position in this case on whether those cases are rightly decided, and we don't think that the court needs to get to it.
Wouldn't your position necessarily determine that those are error as a matter of law?
I don't think so, Justice Paulson. There might be. So first of all, the cases that you're referring to don't clearly articulate a theory of irreparable harm. Many of them don't even discuss it. They simply assume that there's irreparable harm. But there may be, and again, you don't have to get to this question, but there may be theories that would support the idea that that's irreparable harm. The 11th Circuit has some case law, Handley and White, which say that when you are compelled by a private litigant in a civil case to testify, that is not government compulsion. And so the 11th Circuit's case law perhaps raises the specter that the defendant there wouldn't be able to suppress that testimony in a subsequent prosecution. Now, I'm not sure that that's right or that's how this court would come out on the question.
I don't understand why that should be different in a civil and criminal context, because if you're in a civil context, at the heart of the matter, you're afraid of being prosecuted for something that's going to be divulged in that material, right? So it seems like you would be more concerned in a criminal proceeding than you even would be in a civil.
Well, so the distinction I'm trying to draw, Justice Paulson, between the civil cases and the criminal cases that the 11th Circuit has drawn is that perhaps if you're compelled in the civil case, there's been no governmental compulsion. There's no state actor that's compelling you, and thus that testimony and its fruits could be used in the subsequent criminal prosecution. That's not true in the criminal context because it would be the state that would be doing the compulsion. And so the fruit of the poisonous tree doctrine would attach here, and we wouldn't be able to use those fruits against him at trial. But I mean, again, I think that's a much more complicated and nuanced question, one that's not in front of the court.
Well, it seems pretty pertinent to me, at least.
Well, all our submission is that there may be justifications for that line of district court decisions.
Because it goes to irreparable harm. It seems like, I mean, if you say there's irreparable harm in a civil context, why wouldn't there be here?
I think it goes to the point about whether or not there's government compulsion in the civil context.
And so on that point, though, I mean, for us to say that there's no harm here, irreparable harm, does that mean that we have to say that essentially that the compulsion standing alone is not a problem, that there's really no problem for Fifth Amendment purposes until it's actually used against you and it actually matters?
That's exactly right. I mean,
and I understand, I understand in the abstract that argument, but I mean, it doesn't seem like and maybe it's this whole distinction between the prophylactic thing and the actual substantive prohibition, but it seems like it kind of goes against the grain of our system in general to say we're indifferent to the compulsion at this stage. We really only are going to care about it and deem it harm if you end up being convicted of this testimony.
So Justice Muniz, the Castigar case, I do think stands for this idea that the compulsion itself is not the Fifth Amendment injury. That has to be the rule that comes out of Castigar, because Castigar says the government can compel you. In the abstract, there's nothing wrong with that, so long as it immunizes you, meaning it can't harm you at trial by introducing the statements. So there is no abstract dignitary or privacy interest at stake that the Fifth Amendment protects. We can compel you. That's not the problem.
But if it turns out, though, that it was wrong to have compelled, and I know you haven't gotten to the merits yet, but if you were compelled on the basis of a sort of a legal error as to whether this was all that, then that really is harm that cannot be undone. I mean, in terms of the conviction, but so basically it gets back to the compulsion itself just isn't harm that the law recognizes.
Right. Of course, there's a mountain of U.S. Supreme Court case law that indicates just that: Patain, Chavez, Castigar, and of course the en banc 11th Circuit in Gekas. But one way or the other, we know that the fruit of the poisonous tree doctrine would apply to any compelled statements that he may utter, and so anything after that point would be tainted. If there is in fact a Fifth Amendment violation when we compel the passcode that enables us to get into the phone to search it, any physical fruits we find will be tainted. And so his remedy ultimately is that, number one, he could move to suppress at trial on this theory that that hasn't happened yet. We don't know if we will find any fruits. And of course, if he's convicted and sentenced, he can always appeal. I mean, this is the basic structure that our system creates for criminal defendants when they believe that they've been harmed in some way. So defendants could say any number of things would harm them in the sense that they'll be convicted. So erroneously introduced hearsay evidence or Williams rule, collateral crimes evidence, any of that could be harmful at trial and could lead to a conviction, but you don't have the right to seek cert pre-trial. That's Pettis, which says that criminal defendants have no right to interlocutory appeal.
Can I ask you a merits-related question?
Of course.
So does it matter, is this teed up in a way that if we did get to the merits that we could draw this distinction between someone entering the passcode where the government never actually learns what it is, and so you really only do have this testimonial aspect of knowledge and confirming that it's my phone, given that here what was asked for and what the DCA wrote about was actually disclosing the code itself?
So our first position here, which is that this is just not testimonial to begin with, I think that you could resolve that question here on the basis that within the original meaning of the Fifth Amendment, a grant of access so that law enforcement could execute a warrant is just categorically not testimonial. Now, maybe more directly to your point, Perhaps you think that there is some difference between being required to disclose your passcode and being required to enter it. We think that as a functional matter, there really is no difference. The government in this case doesn't care what the contents of the passcode are. That's not useful to us in any way, except that it's a grant of access. So it's not that we care about...
Isn't it demonstrative of ownership and possession at the crime scene?
Yeah, so, right. And that goes to the act of production doctrine, but I understood Justice Muniz's question to suggest that there is some difference for the purpose of this inquiry between disclosing your passcode and being forced to enter it. But to your point, either of those things involve an act of production. There is still an implicit testimony conveyed when he either inputs it or gives it to us. He's saying, I have access to the passcode, I know what it is, and that the passcode exists. Of course, under the foregone conclusion doctrine, we know all of those things. And
You don't know the passcode. I'm just wondering, I mean, it's arguable that the foregone conclusion thing just categorically doesn't apply to the actual passcode. It does apply to these other things that you can infer from the fact that he knows the passcode. And so I was curious about that. I mean, because you suggest, in your brief, you say, well, and it would be less convenient for us, but if he has to just enter the passcode, then that's fine. And I'm just wondering if the court were inclined to kind of take that off ramp, if that's even procedurally sort of an option for us.
So, Justice Muniz, if it was the court's view that there was simply a defect in the form of what the state asked for here, we would take that ruling. I think that's a win for us, because on remand we could simply ask for the right thing. But I think that helps to make the point that, functionally speaking, there's no difference for the purposes that Mr. Garcia is concerned about, which is the act of production. There's no difference if he's required to disclose the passcode, which says that he knows it, or if he's required to manually enter it, which again shows that he knows it, or if he's required to put his thumbprint on the phone to unlock the device with biometrics, which of course would show that it's in fact his phone. So for all the reasons that he cares about, which is this alleged act of production, it all boils down to the same thing. But, I mean, of course, if the court's holding is that there's a problem in what we asked for, that seems to me could be remedied below. So I do want to talk about our threshold theory that this is just not testimonial in the first place. And maybe the plainest way to think about that is that if at the time of the framing, a constable was armed with a warrant to search a home and showed up at the suspect's home, there would have been nothing that the suspect could have done to turn away the law enforcement officer. He had a warrant signed by a magistrate that authorized the search and in fact ordered the law enforcement officer to go and search. And so the constable could have done either of two things. Number one, under Payton versus New York, the U.S. Supreme Court said that it would have been constitutionally reasonable for him to require the suspect to unlock his doors. So the officer could have actually demanded entry and been given entry that way. And second, even barring that, the officer simply could have broken down the door. There were no doors at the time that couldn't have been broken and then entered by law enforcement. So the point is, warrants have always equaled access. And we don't think that changes in technology have changed that basic reality. And it would have been, I think, quite absurd for the constable to have showed up at the home, demanded entry, and for the suspect to have purported to invoke his Fifth Amendment right. No one would have thought that the Fifth Amendment had anything at all to say about this question, which is really a question about search and seizure. And
on access, I think one of the briefs actually raised a question whether you really need the passcode or not to get into the contents of the phone. Is it your position that, yes, you really need the passcode, or can you get it in other means?
So I'll say number one, I don't think that our theory of this being non-testimonial turns on that. We may not have needed the suspect to open the door for us at the framing, but we still could have compelled that. So I think one way or the other, this might be a collateral point. But number two...
So you may not need the passcode, but you still want it?
It appeared... Well, there may be some cases where we could get into the phone. The record here says that we could not and that we tried to do a forensic download. More broadly, there's been some debate about whether technology out there allows us to decrypt phones. What I can tell you, based on our conversations with FDLE, this is my understanding, there are really two camps of devices that we might try to get into that could be encrypted. The first would be hard drives, laptops, computers. FDLE says it can be nearly impossible to crack those if they receive the device with the basic encryption that ships from the factory enabled. It can be almost impossible. The second camp, of course, is what's at issue here, cell phones, although I think your ruling will apply across the board. With cell phones, the case is a little bit better for us. There are some devices that we can get into. It depends on whether these technology companies, Celebrite and Grayshift, have been able to crack those devices. Newer devices, it's much harder, and it may even matter the state that the phone comes in. So that's perhaps a technical answer, but it looks like even now there will be many devices we can't get into. However, even more generally, what Professor Kerr says is that this is an arms race between encryption and decryption, and encryption over time is likely to ultimately prevail because of the mathematics here. So even if tomorrow we had the technology to get into Mr. Garcia's phone, a month from now, the software companies might send out an operating system update, which would divest us of that ability.
So on your point, though, about it not being testimony, it seems like both the courts and the academics who agree with on your ultimate position on the merits say that they do think that it is testimonial. And is there a good authority on the other side in this? I'm not just by analogy to letting someone into your house, but what's the best authority looking at this specific question that just says at the threshold it's not testimonial at all?
So the Stahl case comes close, although at the end of the day it still applies the foregone conclusion doctrine. So I don't quite think it's in our corner there. The fact of the matter is, Justice Muniz, the theory that we've advanced of this being simply non-testimonial at the gate is a theory that hasn't been adopted by any court. I don't know that it's been advanced in any court. So it is a little bit something new as far as the doctrine that's out there. As far as U.S. Supreme Court cases that, none of them are on point, but there are some that are useful guidance. I think that the Doe 2 case comes very close as far as physical analogs go. So what happens in Doe 2 is that the government learns that Doe has foreign bank accounts, and the government, of course, can't get in unless it has a signed consent agreement from Doe. And so it asks him to fill out this consent form, which requires his signature. And of course, if the signature doesn't match whatever signature the bank has on file, the bank's not going to let the government in. And so it needs the signature to be accurate. And of course, a signature uses the contents of the mind. And what the Supreme Court said there was that that wasn't testimonial. That is just signing a piece of paper that's more or less equivocal that has, as an incident to the signature, a grant of access. That's what we think is happening here. So the passcode here is more or less the same as the signature. If it's not accurate, then access isn't granted, and the court says, well, that's okay. That's not testimonial. So what we're asking for is maybe something a little bit different from what the other courts have done, but I still think we're on firm footing. And I'd go back to the House analogy because I think it's a potent one. Again, he has no right in 1791 to say, I'm not letting you in because of my Fifth Amendment privilege.
I can't remember if it's Doe 1 or Doe 2, where there's the discussion about comparing access to a combination for a safe,
right,
as opposed to a key. I think that's the comparison.
Right.
They were saying what they authorized there, they thought was more like a key than the combination to a safe. Am I remembering that correctly?
Yes. So
doesn't that now? Maybe that's dicta, whatever. But doesn't that kind of cut against you here?
Well, I'm not sure. In the context of Doe 2, where the analogy was first used, the court, I think, believed that the signature was more like the key, and thus was non-testimonial. Now,
but in the context there, doesn't it suggest that the requiring the combination to the safe would be problematic? No, they've essentially conceded that.
So two things about that, Chief Justice Kennedy. The first is that those are not cases. So that language appears in Hubble as well, in the majority opinion in Hubble. Those cases are not search warrant cases. And so our theory of this being non-testimonial turns on the existence of the search warrant. So number one, I think it's inapplicable for that reason. And number two, even in Hubble, I think it's dicta. It's a helpful analogy that the court relied on, but the court didn't purport to resolve that question. And so you can still decide whether you think that that analogy makes sense in this context. And we think ultimately it doesn't, because for the reasons I was discussing with Justice Muniz, there's no practical, functional difference between revealing the passcode and being forced to manually unlock the phone.
Counsel, we have eaten up your rebuttal time here. I'm going to give you 3 additional minutes, but that's starting to run now. So
thank you very much.
May it please the court. My name is Robert Adams. I am appearing on behalf of the respondent, Jonathan David Garcia. Your Honors, forcing a criminal defendant to disclose a passcode violates the Fifth Amendment because it compels the defendant to become a witness against himself. The Fifth DCA agreed with this proposition, and despite the state's arguments to the contrary, the Fifth DCA had jurisdiction to issue its writ of certiorari. The trial court's order did compel actual testimony from Mr. Garcia, to which the foregone conclusion exception has not been applied and should not be applied. And the foregone conclusion exception, if it were to be applied by the court, should require the state to demonstrate by a high burden at an evidentiary hearing before the trial court that what they're seeking, the testimonial value of what they're seeking actually is a foregone conclusion based on the information they already have. And that was not done below, so it cannot be applied here. Turning to the question of jurisdiction, petitioner claims that Mr. Garcia has not suffered any injury, will not suffer any injury from the compulsion order itself. This is not correct. The compulsion order does injure the defendant in the same way that Justice Polston suggested it would injure a civil litigant, that the district courts have accepted. The concept here of an irremediable harm, a harm that cannot be adequately remedied on appeal, is that if you were to compel a civil litigant to provide the answer to the question that supposedly brings about incriminating information, that civil litigant may be subjected to criminal prosecution that they're not currently facing. That's true even where the defendant is already facing some criminal prosecution, because if the compelled communication provides evidence of crimes to which the law enforcement does not know, they're now going to be facing further prosecution. For instance, in this case, we had the alleged victim come to law enforcement after the issuance of the arrest warrant and say, I found this GPS device in my car. I believe that Mr. Garcia planted it there.
But when is that injury suffered? Is it suffered when law enforcement learns of these additional facts, or when the prosecution happens and the trial rights attach?
It would be suffered when he's compelled to give the statement that gives law enforcement that knowledge to support bringing about the charge.
I guess my trouble with that is that it would seem like perhaps you're speaking about some privacy interests that you're saying sort of floats around the trial right. But I don't see in what Mr. D'Souza referred to as the mountain of Supreme Court case law any support for that proposition. I find instead support for the proposition that the injury is suffered when jeopardy attaches and evidence is introduced and the jury relies upon that evidence. Help me understand how this more attenuated interest or this different interest somehow attaches as soon as the law enforcement team learns what it learns.
Well, once they've learned that information, the mere fact that the litigant in a civil case or the defendant in a criminal case can be subjected to criminal prosecution they weren't previously facing would be itself a harm. It would put them.
I'm not sure I agree. Can you direct me to a case that says that the existence of that possibility is itself a harm as opposed to the prosecution?
Sure. There's the Aguila case from the Third DCA. There's also cases that were cited in both the initial brief and the answer brief, recognizing that these are the opinions of multiple district courts below. I don't think even the petitioner is disagreeing that those were the holdings of civil cases that compelling a civil litigant, normally in the context of a deposition, to provide what could be incriminating testimony in that deposition might open them up not only to the prospect of having to reveal privileged information, but to the prospect of having to reveal information about crimes that are not yet known. And while the petitioner claimed in the initial brief that those cases are an apposite to a case that involves a criminal defendant, we just don't see that to be true. It seems to be a distinction without a meaningful difference. Both of these people, the civil litigant and the criminal defendant, Mr. Garcia, are in that same position. Given how ubiquitous cell phones are with everyday life and how often they're used for things that would involve privileged communications, it's also entirely plausible that if a criminal defendant were to provide that kind of access by divulging the passcode, by giving that testimony, that they would also end up opening the door to privileged information as well, the same way that the civil litigant would when the DCA's decided that that civil litigant had a harm that could not be remedied on direct appeal, because once that cat is out of the bag, it can't be put back in. Once that bell is rung, it can't be unrung. So unfortunately, it creates a situation where if the DCAs are incorrect, up until the Foster case from the First District Court, then the litigant would be in the position of having to attest in their petition, or perhaps in a response to a motion to dismiss, as to what specifically the harm would be that they would face from being compelled to give this incriminating statement. And of course, that creates a paradoxical circumstance where the litigant is having to give some indicia of what the harm they will suffer is, give some indication of what new evidence of an unknown crime or what privileged information might actually exist in the contents of their statement, or by implication from the contents of their statement. And to do that would be to essentially say, well, in order to assert your Fifth Amendment right against compelled self-incrimination, you're going to have to do a little bit of self-incrimination so that we know that you're coming to us with a genuine article of harm.
What do you make of the fact that the amendment speaks of being a witness against yourself, right? It doesn't say of supplying information. It doesn't say of providing inferences. It says of being a witness, right?
That's true. Your Honor, for that, I would direct the Court's attention to the Hubble case from the United States Supreme Court. That addresses, we believe, the state's argument that this is exclusively a trial right. We don't think that the United States Supreme Court agrees with that interpretation. And Justice Stevens's writing for the majority opinion said that the phrase "in any criminal case" in the text of the Fifth Amendment might have been read to limit its coverage to compel testimony that's used against the defendant in the trial itself. It has, however, long been settled that its protection encompasses compelled statements that lead to the discovery of incriminating evidence, even though the statements themselves are not incriminating and are not introduced into evidence. So it divorces this concept of the harm from a statement and the potential for violating the Fifth Amendment from the question of what actually ends up getting used at trial. And the fact that you're being asked to, you're being forced to compel, or being forced to provide self-incriminating information or give a self-incriminating statement, even if it isn't ultimately used, is not the question. The question is whether or not that act in and of itself violates the Fifth Amendment. Now, it may not provide grounds for bringing a 1983 claim in federal court for damages, but it does create a violation that the DCA has seen as cognizable for a number of civil litigants, and for which there's no difference for a criminal defendant who's facing the same type of order.
Can I ask you, I'm sorry, I know that on the certiorari issues, most of the arguments have focused on the harm question, but isn't the other part of the test that that the error has to be something where the law that was departed from by the trial court was clearly established? And it doesn't seem to me like this seems like the opposite of clearly established.
To that, our argument is that it is clearly established because it's clear from the meaning of the Fifth Amendment. It's clearly established because this circumstance clearly involves an order compelling Mr. Garcia to testify against himself. This isn't like the circumstances of Fisher or Doe and Doe 2. It's more like the concurring opinions suggestion of the difference between providing a combination to a lock versus a key. Based on those opinions, the essential requirements of the law would have compelled Judge Adams to look at the circumstances and say, you're asking state for the court to give an order that compels Mr. Garcia to reveal the contents of his mind, not to give you a key or unlock a cabinet like in the Fisher case and hand over a document inside the cabinet, but instead you're asking him to essentially reveal something that's only contained in his memory. And it's not a pre-existing document. You're asking him to create that testimony today, this afternoon, tomorrow morning. It happened to be tomorrow morning because Mr. Garcia wasn't present that day. But either way, whether it's we're going to show you the phone screen, you're going to type it in front of us, you're going to write it down, hand it to your attorney hands it to us, you speak it in open court, all of those still require the defendant to actually probe the contents of his mind, assuming he is the owner of the phone, and then reveal the contents of his mind. It relies on his truth-telling function, which is also a distinguishable element that's noted in the Fisher case. Because if he gives the wrong passcode, he can face perjury. It's entirely possible that he could give the wrong passcode.
But how does this, you're talking about the contents of the mind, how does this, how does that fit in with the circumstance where there's, you can get in with your fingerprint? Fingerprint's not the contents of your mind. And it may be, you don't even have to show them, you just give them your hand. and they, say which digit, they try the digits, and they get in that way. How does that, should that in principle be treated differently because it's not a revelation of the contents of someone's mind?
Yes, it should. And to be clear, there's a couple of problems with approaching this particular issue before the court on these circumstances with that analysis because, as both the petitioner and respondent have recognized, realistically speaking, the fingerprint probably won't provide access at this point. Most phones have a timeout lock that require you to use a passcode. So unfortunately, that wouldn't be an effective order, and we just end up coming right back around to seeking review from this court. The other problem with that is, if it were to be like a normal order for fingerprint exemplars, where the court is compelling the defendant to show up and place all 10 fingers on an ink pad and then place the inked fingers all on a piece of paper, and then all of those prints would be compared against whatever latent prints were pulled from a crime scene, that would not be testimonial. It's well established that's non-testimonial act of surrender or act of production. However, if the order were to say instead, use the finger that you used to lock this phone.
Yeah, but my question didn't ask about that. It was assuming that just give them the hands. And
Sure, if it
they
was
have
just,
to go through it one by one.
If it was
Or
identical,
maybe start with the thumb because that's maybe the most likely one.
and if it were identical to fingerprint exemplars, where it was just a process of elimination going through each finger, and he was just compelled, put this finger, put this finger, put this finger, without asking him to use the contents of his mind, that would absolutely be distinguishable. But it's not the same as being.
What sense does that make? I'm just trying to understand why, given the whole context here, that is not just a hyper formalistic way of looking at this.
Well, it would be distinguishable in the sense that because it doesn't probe the contents of his mind, and because he doesn't actually concede anything by just putting his finger on a piece of glass or whatever it may be, that doesn't have the same testimonial qualities that being asked to produce something that's only contained in his mind would. There are some implicit testimonial qualities to the mere fact that he could unlock the phone, and those might be subject to the foregone conclusion. But that would stray far from the actual facts that the court is presented with in this case, where inescapably what the court is telling the defendant, or the trial court was telling the defendant you have to do, is tell the state the passcode that's contained in your mind.
But doesn't your whole, your whole bigger picture argument hinges though on the idea that, and I don't agree with you on this actually, but the idea that you don't just focus on the communication that's inherent in unlocking the phone, but that you actually lump in everything that's on the phone too. And so if the prohibition is on, helping the government sort of prove its case against you because you're giving, you're essentially being made to be kind of, part of them gathering their evidence, that's on the phone and everything. Isn't that the problem with the thumb issue? Is that in the same way of, just revealing the passcode in some other way, that you're basically roping the defendant into actually the contents of the phone?
That's true. And in that respect, it may have implicit testimonial qualities. And in that respect, it may be a situation where the state needs to demonstrate a foregone conclusion exception has been met in order to compel the fingerprint. But to say that it is tantamount to testimony in the way that the trial court's order below is tantamount to testimony, I think there is a distinguishable difference. I think there's a difference between saying you're required to tell us something you have memorized versus you're required to just, in order, put all of your fingers on this phone until it either unlocks or never unlocks.
So then do you also think that there's a difference between revealing the code versus typing it in without the government knowing what you typed in?
Yes. Because in both of those cases, you're still asking the defendant to utilize the contents of his mind in order to unlock the phone. And in both cases, you're creating evidence where that could be used at trial, even if, hypothetically, the phone were subsequently searched and no relevant information were found in the phone. A witness who was in court that day, say the investigating officer who showed up for the motion to compel hearing, could come into court and say that on such and such date, the defendant was compelled to unlock the phone with his fingers. He was shown the phone and he typed in some numbers. I didn't see what numbers, but after the phone was handed back to law enforcement, the phone was unlocked, from which the jury would be free to infer that he had the passcode that was effective at the time that the phone was recovered from the crime scene, which then infers that he was the one in possession of the phone when it was left at the crime scene, making the state's case that he was the one who actually was at the alleged victim's new boyfriend's home and had smashed the window.
Would there be some sense in sort of looking at this in a new way and bifurcating the way you analyze the issue based on the purpose for which the request is made? For example, even with like a key to a safe, I would think that if the government compelled someone to open the safe, they didn't, that act of opening the safe with their own key, they couldn't bring in an agent to say, well, we're going to prove that he had control over the safe because he got the key and it was his key and he unlocked it. And so that seems like it would be problematic if you look at the original intent and meaning of the Fifth Amendment, that compelled act. But conversely, if the government forces you to compel the passcode or anything else that requires mental process or anything else, of course that would mean that they couldn't use that information to prove control, but that's not the purpose. Why can't we look at it? Because I think Mr. D'Souza is correct that the Fifth Amendment was not intended to allow the privilege to be asserted in order to thwart the government's access to information that they had a lawful warrant to access. So it seems like there ought to be, does that make sense?
Yeah, but respectfully, respondent believes that conflates a Fourth Amendment issue with a Fifth Amendment issue. There's a difference between law enforcement having the ability, once it shows a magistrate or on-call judge that they have probable cause to acquire a search warrant and then go into a home, versus asking the defendant to participate in providing them with incriminating evidence that would further their search. So to say that it's obstructing them from performing the search is just the happenstance of this particular quirk to the development of this technology in the digital age. The reality is that encryption technology has to be defeated by decryption technology, which respondent believes that actually is available to the petitioner.
What about encryption without technology? I mean, you're forgiven for not briefing this because only Justice Muniz brought this to my attention, but Professor Kerr writes in the current issue of the Harvard Law Review about a letter written in cipher, right? And Chief Justice Marshall decides that it is not an act barred by the Fifth Amendment for a court to compel someone to admit that they know what the cipher is, what the code is, what secret letter is used to decode a communication. Would you still have the same arguments if it were an old school version of encryption? That is, I wrote this letter, it's in code, and I refuse to tell you what the code is to make sense of the words. All the same arguments apply?
I believe the same analysis applies. If it was a circumstance like Fisher, where there was a codex that converted the cipher to plain language that was previously created by the defendant, and potentially even held by another, perhaps whoever the message was being sent to, then that compelled production would be different because it doesn't require the defendant to probe the contents of his own mind in order to provide that information. If the order is compelling him to probe the contents of his mind and provide or create a codex that says this is how you decipher my cipher, and give plain meaning to the document that the state has that they think might contain incriminating evidence, then that would be the same analysis and would reach, we think, the same conclusion, which is that you're asking the defendant to become a witness against himself, regardless of whether or not that actually leads to information that you use at trial, because it raises the possibility that you don't know what's in the document, just as you don't know what is in the phone or what may come out of the statement that the defendant is invoking the Fifth to avoid revealing. You don't know yet what information might be involved. You don't know whether it's going to involve privileged information, whether it's going to involve information that relates to other crimes. And because of that specter of a new harm that cannot be remedied on direct appeal because it's already out of the bag, that creates the full violation, the total violation for the purposes of appellate review, for the purposes of seeking certiorari jurisdiction before Florida District Court.
I mean, that's it seems like your side is the one that's conflating the Fourth and the Fifth Amendment interest. I mean, it seems like sort of overbreadth and getting access to more on the phone than what the government really should be able to access for purposes of investigating this crime. It seems like that all of those things really should be dealt with as a Fourth Amendment issue and not sort of swept into this issue of giving the government access, just like, letting the government into your house and then what they're allowed to do once they're in there.
Well, except that the problem again is that if he is compelled to provide a passcode, assuming that he can, assuming that the passcode works and unlocks the phone, that in and of itself provided evidence the state didn't previously have. At least that's our contention. The state doesn't
at most, the ownership of the phone, which in this case, I know you're saying that it's disputed, but if this case were just about whether there was enough evidence to show that it was his phone, that's not why we're here. Let's assume the state has evidence that it is your client's phone, and it's really just a matter of unlocking it. Where does that leave us?
I think then the question still remains about what kind of testimony the state is asking the defendant to provide, whether it's an act of production or whether it's actually testimonial. So long as the order requires him to delve into the contents of his mind to provide the passcode, our position is that's still testimony.
Right, but then then the foregone conclusion doctrine comes into play, right?
We only believe the foregone conclusion doctrine comes into play when we're dealing with an act of production, not with actual testimony. When the act of production may have testimonial qualities, then the state can demonstrate with that something is a foregone conclusion, that the phone is locked, that the defendant has the passcode to that phone to unlock it, and that the evidence that they're seeking behind the passcode wall, they can identify and they know to be there. That in the language of Fisher, that it exists and that it's authentic. That if they can demonstrate that those things are a foregone conclusion, we argue that beyond a reasonable doubt standard would be the appropriate one to protect such an essential right, then the state would be able to do it, assuming that it no longer requires the defendant to probe into the contents of his mind.
Counsel, you are a couple of minutes over at this point, but we have helped you with that. So I'll give you another minute to sum up.
Thank you, Your Honor. Because the trial court's order compels the defendant to provide some statement that has not yet been entered, it is different from the situation where the defendant is coming to the court with a motion to suppress, trying to get the exclusionary rule to apply to suppress statements that have already come out through what's arguably a coercive interrogation, which are the cases that the state relies on to argue that there's no cognizable injury yet for the certiorari review. This circumstance creates the specter of a harm that cannot be adequately remedied on direct appeal because you do not yet know the contents of the compelled testimony. And since the contents of the compelled testimony, just as in a civil case, may involve information that is privileged and may involve information that incriminates the defendant for crimes that he's not currently facing, he has a harm in complying with that order. Also because it creates this ultimatum of either comply with the order or face a new charge of contempt. In those circumstances, we believe that certiorari jurisdiction does properly lie, that the 5th District had proper certiorari jurisdiction to issue its order quashing the trial court's order. We believe that the trial court's order does compel actual testimony to which the foregone conclusion exception does not apply because it requires the defendant inescapably to use the contents of his mind to provide incriminating information against himself. For those reasons, we ask the court to affirm the 5th DCA's order. Thank you.
Thank you, counsel. Rebuttal.
Thank you. So I'll start again with irreparable injury. There have been some additional theories, I think, propounded by Mr. Garcia at oral argument, but in the briefs and below, he was quite clear about what he believed that his injuries were. And perhaps the clearest place you can find this would be page 5 of his reply in the district court. He said he would be harmed in 2 very specific ways. He said, number 1, if I'm required to turn over my passcode, law enforcement will be able to execute the search warrant, and they may find evidence that is damaging to me and can be used in the criminal prosecution to prove my guilt. Now, we know that the fruit of the poisonous tree doctrine would apply to all of that, and I think that takes that off the table. And then he said, number 2, my act of producing the passcode could be used against me to show that it was my phone. Again, however, if that were introduced at trial, which we don't intend to introduce against him, but even if that were introduced against him at trial, he would still have the same remedy that criminal defendants always have, which would be to simply take an appeal.
You're saying what's new is this idea that there could be things on the phone that are completely other criminal relevant stuff that has nothing to do with this.
So we think that
you're saying that's what you were alluding to with the new theory.
I think that's part of it. So certainly he has now cited the the civil discovery cases. That's not the theory that he pled in his petition, and he was very specific in his petition. So Judge Luck, concurring for the 3rd District, made what we think is a good point, which is that how can a district court assess irreparable injury based on injuries that the defendant himself has not asserted that he has suffered? So I think, number one, that perhaps clears up some of that. Number two, going to the merits, Justice Carroll, you referenced Professor Kerr's decryption originalism article. I think, of course, that article helps us, but our case is somewhat stronger still for 2 reasons. Number one, in the Aaron Burr trial, there was no warrant involved, so far as the transcripts in that case that I read revealed. So the fact that we do have a warrant suggests that we have a right of access. Number two, in that case, to decipher the documents would have been to effectively translate the documents from one language into another. And so the document itself that was evidence was protected by a cipher. All we're saying is that we need to get past a door. That door is encrypted, but it's not as though once we get past the door, we'll need him to translate the documents for us. So I do think this is a somewhat easier case. I'd like to answer any additional questions that the court may have, but I have nothing further to add at this point.
We thank you both for your arguments in this case today. That is the last case on today's docket. The court will now be adjourned.
All right.